Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss a preliminary injunction that was obtained by the American Federation of Government Employees and other plaintiffs, which placed on the Trump administration in regards to the administration's unlawful termination of probational federal government employees from agencies including the U.S. Department of Energy, Agriculture, National Science Foundation, Internal Revenue Service, Department of Veterans Affairs, Department of Defense, Forest Service, National Oceanic and Atmospheric Administration, Department of Commerce, Education, Health and Human Services, Homeland Security, Housing and Urban Development, Interior, Treasury, Transportation, Environmental Protection Agency, General Services Administration, and Small Business Administration. This order placed an injunction on further illegal conduct from the administration's Office of Personnel Management. The administration's appeal of the order is currently in the appellate briefing stage in the U.S. District Court for the Ninth Circuit. Oral argument should be set at some point in the future of the Ninth Circuit to decide whether the injunction should be lifted while the merits of the case goes through the courts for review. The injunction prevents the Federal Office of Personnel Management from, among other things, from, quote, ordering, directing, or telling federal agencies to terminate any federal employees. The injunction also requires, among other items, for OPM to provide recipient former probationary government employees who were terminated with a template notice referencing, quote, performance as the reason for termination with, quote, a written statement directed to the employee individually stating that their termination was not performance or fitness based, but was made as part of a government-wide mass termination. I'm going to quote from Judge William Alsup of the U.S. District Court for the Northern District of California's April 18th, 2025 injunction order. The first sentence under the section caption Findings of Fact, quote, in February 2025, the United States Office of Personnel Management unlawfully directed the mass termination of thousands of probationary employees in all federal agencies. OPM did not merely suggest such terminations, it directed them. OPM directed federal agencies to fire their probationary employees. In a January 20th memo to federal agencies, OPM directed each agency to identify all employees on probationary periods and send a list to OPM. The memo explained, quote, employees on probationary periods can be terminated during that period without triggering appeal rights to the Merit Systems Protection Board. In a February 12th email, OPM directed agencies to, quote, to action those you wish to separate by the end of the day tomorrow, 2/13/2025, using the attached template letter, and requested further daily progress reports through at least the end of the week. At this time, OPM conducted conference calls with the Chief Human Capital Officer Council every day. OPM also held probably about maybe 7 to 15 individual calls with various chiefs of staff and other agency political appointees concerning probationary employees. Despite requests by the district judge, defendants have declined to place direct evidence of the contents of those calls into the record. In a February 14th email, OPM pushed the action deadline back, stating, we have asked that you separate probationary employees that you have not identified as mission critical no later than end of day, Monday, February 17th. We have attached a template letter. In a February 21st Internal Revenue Service town hall, IRS Chief Human Capital Officer Tracy DeMartini stated, quote, "I'm not sure why it's happening. Regarding the removal of the probationary employees, again, that was something that was directed from OPM. And even the letters that your colleagues received yesterday were letters that were written by OPM but put forth through Treasury and given to us. I cannot explain to you why this has happened. I've never seen OPM direct people at any agency to terminate. And our actions are being watched by OPM, so that's again something else that's unprecedented." On February 25th, Tracy Thierot, Chief Human Capital Officer of the Department of Veterans Affairs, testified under oath at a congressional hearing before the House Committee on Veterans Affairs. Ranking Member Tacono, "So nobody ordered you to carry out these terminations? You did it on your own?" Ms. Thierot, "There was direction from the Office of Personnel Management." On February 26th, members of the Civilian Personnel Policy Council at the Department of Defense stated by email, quote, "In accordance with direction from OPM, beginning February 28th, 2025, all DoD components must terminate the employment of all individuals who are currently serving a probationary or trial period." Judge Alsup cites other evidence in the record that indicates that the Office of Personnel Management ordered these various agencies to unlawfully terminate the probationary government employees. Judge Alsup then stated, quote, "The template was a sham, citing performance as the basis for the termination in order to evade statutory and regulatory requirements, including, for example, the construction of an order of retention that honors veterans' preference eligibility. OPM's directive constituted an ultra-virus act that infringed upon all impacted agencies' statutory authority to hire and fire their own employees." The judge, in his analysis, quoted the U.S. Supreme Court in a case captioned "Armstrong versus Exceptional Child Center" out of 2015, stating, quote, "The ability to sue to enjoin unconstitutional actions by state and federal officers is the creation of federal courts of equity and reflects a long history of judicial review of illegal executive action tracing back to England. No statute anywhere ever has granted OPM the authority to direct the termination of employees and other agencies. Administrative agencies like OPM are creatures of statute. They accordingly possess only the authority that Congress has provided. Congress's statutory scheme grants to each agency head the authority to manage its own affairs, including the hiring and firing of employees. OPM did not have the authority to direct the firing of employees, probationary or otherwise, in any other federal agency." The judge further in the order stated, quote, "As IRS Chief Human Capital Officer DeMartini explained, quote, it would take weeks or months to evaluate the job performance of 6,700 probationary employees. OPM's deadline, meanwhile, afforded federal agencies mere days. As a result, countless high-performing employees were terminated through a lie. Termination under the false pretense of performance is an injury that will persist for the working life of each civil servant. In pursuing future employment, each will have to concede that they have been terminated based on performance. The stain created by OPM's pretense will follow each employee through their careers and will limit their professional opportunities." Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.